Madam Mayor. Councilmember Brown?
Yes.
Councilmember Sullivan Leonard?
Yes.
Councilmember Brown?
Yes.
Councilmember Rubio?
Yes.
Councilmember Vilak?
Yes.
Motion to adopt ordinance serial number 2216 passes unanimously. Sullivan Leonard, Graham, Brown, Vilak, and Rubio in support.
We are now at persons to be heard. And tonight we have Mr. Stearns.
Good evening. My name is Tom Stearns. I'm the Senior Ambassador for the Wasilla Area Seniors Incorporated. We still have board vacancies, so if anybody's interested, but we only have one seat now instead of two. So if you're interested, you'll have to get there quickly. Friday, the 27th, this coming Friday, WASI has their Wasilla area memorial tree dedication ceremony. It's a ceremony we have every year. We plant a tree for all of the people that have died the previous year. And we have a little plaque, and we plant the tree, and we have a little ceremony for that. And so that will be at 12:45 this Friday. Then the big deal coming up is Miles for Meals, and you have the information there. Miles for Meals this month, we are focusing on getting support for this event, either via donations for our auction or pledges, sponsorships for the event on June 25th. Gear up to run, walk, or roll at the 2022 Miles for Meals on Wheels 5K Fun Run. Registration $25. Sign-in begins at 9 a.m. and the fun run at 10. Barbecue follows. And you can also do the virtual run, walk, or roll, and that goes from 1st of June to the 25th of June. In your space, at your pace. This is a family event, so we would like all are welcome. Miles for Meals online auction begins 4 June and goes through 18 June at 7 o'clock. Now, I'm going to give you the inside scoop, okay? The inside scoop is that you can go to our website and you can find out all the goodies that are in the auction sometime later this week. I got that from a good source. Gardening. And by the way, what Miles for Meals is for is to feed our seniors, okay? We don't just feed seniors here in Wasilla. We feed them in Palmer, and we feed them up north, going all the way to Willow, okay? So we are on pace to serve 132,000 meals this year. That's a lot of meals. So anyway, moving on, gardening. Marlene is working on the gardening project for the Willow House. Garden planters were donated by Tote Maritime. We will be utilizing the volunteer labor to install, looking for manure, garden soil donations to fill. Her plan is to begin installing sometime in the end of May. So that's coming up. And then the last thing, gosh, I got through that fast. Monday, June 13th, from 1 to 3, we will have a legal clinic for seniors. They will be discussing advanced health care directives, power of attorney, DNR, and estate planning. So those are what's going on, and I think I've covered everything. Are there any questions? No questions. All right, and I expect you all to be at our event on the 25th or do the virtual. Thank you very much.
Thank you, Mr. Stearns. Ron Bassett? Please begin by stating your first and last name. You have 3 minutes.
Is it appropriate to share a picture of the facility I'll be talking about?
Sure.
Pass these out.
My name is Ron Fassett, and I am the VP of Development for Valley Residential Services, VRS for short. VRS is a nonprofit housing provider here in the Valley, and our mission is to provide safe and affordable housing for people of low income, people who are challenged developmentally, behaviorally, physically, and for seniors. I'd like to thank you for this opportunity this evening to testify in support of our request for $100,000 in funding for the improvement of the Vista Rose Senior Apartments. Vista Rose is located on 1250 Lucille Street, just above the Primrose Senior Facility. Built in 2017 and 2018, this facility has 78 units of housing for seniors aged 55 plus and who income qualify for low-income tax credit housing. There are 37 one-bedroom apartments and 39 two-bedroom apartments, and this facility has a variety of amenities inside, including a common community room with a business center, an exercise room, a reading room, and a kitchen area with a small dining area to support such events as family gatherings and family events. Outside there is a central courtyard with benches, a community garden with raised planters, picnic tables with a barbecue under a pergola, and a fenced-in dog park. Valley Residential Services would like to improve the safety and accessibility of this property for our senior residents by utilizing this funding along with augmented funds for some capital improvements, such as adding accessible push-buttons automatic door openers to internal doors and corridors to improve access within the entire facility. Funds would also be used to relocate the outdoor postal mailboxes inside to the community room area, which would provide safe access to residents' mail year-round, especially during the cold, snowy winter months. Funding may also be used for the purchase and installation of sidewalk coverings for the existing walkways, which would provide safer passage to our residents' vehicles and other outside areas. VRS believes these items would provide our seniors a better quality of life and reduce access barriers while improving safety of the property to our seniors. Our Residential Services would like to request that the City of Wasilla award the $100,000 in funding for the improvements of Vista Rose seniors to help ensure the seniors are able to safely move around the property, especially in the winter months, and to continue to live independently in their home in the Vista Rose apartments as long as possible.
Thank you, sir. Is there any questions? Mr. Graham?
Thank you, Madam Mayor, and thank you for your presentation. So what, the improvements that you described, what portion of the funding will be provided through Valley Residential Services through their fundraising and other grant opportunities versus what the $100,000 that you're asking for? Is the $100,000 80%, 90%, 50%? Do you have an idea what that is?
No, I don't have an idea at this particular point in time what that is.
Could you get?
I could look into that, get back to you on that, yes.
Thank you, sir. I appreciate it. Thank you, Madam Mayor.
Mr. Graham?
So do you have an estimated cost to do all the things that you just named?
No, I don't at this point in time. I mean, this is a wish list of what we would like to do, and we're just starting to develop the funding for this at this point in time.
Any further questions? Mr. because it's my understanding, please correct me if I'm wrong, that the seniors are plugging their car in, running the extension cord into their house across the sidewalk.
On occasions, that has happened, and one of the items on my wish list is to correct that problem.
All right. Thank you, sir. Okay, is there anybody else that would like to address the council at this time? Hearing none, we are moving on to the consent agenda. Madam Deputy Clerk, please read title of the items for approval under the consent agenda.
Thank you, Madam Mayor. Items for approval under the consent agenda this evening are the regular meeting minutes of May 9th, 2022. There are 4 ordinances up for introduction with a recommended public hearing date of June 13th, 2022. First one is ordinance serial number 2217, authorizing the mayor to enter into a use agreement and permit with the Alaska Homeowners Association for a static archery range in the eastern corner of Lake Lucille Park, located on Lot B1, Section 16, Township 17 North, Range 1 West, Seward Meridian. Ordinance serial number 2218, amending the fiscal year 2022 budget by accepting and appropriating a $35,000 grant from the Matsu Trails and Parks Foundation for improvements to the Idita Park tennis courts. Ordinance serial number 2219, amending the fiscal year 2022 budget by appropriating $59,866 from the Water Fund fund balance for the Spruce Alternative Well and well pump replacement. Ordinance serial number 2220, amending the fiscal year 2022 budget by appropriating $160,000 from the Sewer Fund fund balance and $185,000 from the Water Fund fund balance for Hurley Circle utility extensions. There is one resolution recommended for approval. This is resolution serial number 2208, adopting fiscal year 2023 salary structure and pay ranges for non-represented International Union of Operating Engineers, Local 302, and Alaska District Council of Laborers, Local 341, employees of the City of Wasilla. There is one action memorandum recommended for approval. This is AM 2211, confirming the mayoral appointments to the Landscape Standards Review Committee. Those are the items on tonight's consent agenda.
Is there a motion to approve the consent agenda as read?
Madam Mayor, I move the consent agenda as read.
Is there a second?
I second that.
It's been moved by Councilmember Graham and seconded by Councilmember Vigalock to approve the consent agenda as read. Is there objection to the motion? Hearing none, the motion is approved. And before we continue to unfinished business, we will take a 15-minute recess to acknowledge and thank Finance Director Tankersley, who will be retiring at the end of the month. Mr. Tankersley has been with the City of Wasilla since 2008. We sincerely thank him for his dedicated service. We have refreshments in
The agenda, and this is amending Wasilla Municipal Code Title II Administration by adding Chapter 2.01 Code of Ethics and Chapter 2.02 Ethics Complaints to enact a code of ethics and an ethics complaint process, amending WMC 2.76.040 duties to authorize hearing officers to determine ethics complaints for the purpose of implementing a code of ethics and enforcement process for city officials, amending WMC 3.90.050 conflicting interests prohibited, and WMC 3.90.060 prohibited acts, to apply Chapter 2.01 Code of Ethics, conflict of interest definitions to employee conduct, repealing WMC Chapter 2.12 City Officers Generally, WMC 2.44 5.100 conflict of interest, WMC 5.08.200 ethics of contracting and purchasing, and incorporating parts of these provisions into Chapter 2.01 Code of Ethics, repealing WMC 5.14.040 ethics and conflict of interest in its entirety, and consolidating ethical rules and definitions applicable to city officers in a single chapter. This was postponed from the May 9th, 2022 meeting. The public hearing is closed. The motion to adopt as amended is pending.
Madam Mayor, I'd like to request that we move ordinance serial number 2213 to date certain for June 13th for the reasons that Councilmember Johnson is not here and has specific questions that I think are important enough for him to be here to be able to address and actively debate with council.
Madam Mayor, I second that.
Any objection?
Is there any objection to the motion? Hearing none, it is moved to time certain on to the next regular meeting of June 13th. And we are on to new business. Madam Deputy Clerk, please read the title of the first item.
Thank you. This is an update from the administration on emergency response efforts related to COVID-19.
I have not taken any new measures in response to COVID-19. Madam Deputy Clerk, please read the title of the next item of business.
Thank you, Madam Mayor. This is AM number 2212, authorizing staff to submit a request for opinion from the State of Alaska Attorney General on the proposed ordinance adopting WMC Chapter 9.10 sex offenders. And this is open for a committee of the whole, after the committee of the whole consideration and action, AM.
Is there a motion to enter a committee of the whole?
Madam Mayor, I move that council moves into a committee of the whole.
Is there a second?
Second.
It has been moved by Councilmember Sullivan Leonard, seconded by Councilmember Graham to enter a committee of the whole to discuss AM number 22-12. Is there objection to the motion? Hearing none, the motion is approved. Okay, who wants to, I guess, Holly, you want to lead this?
Can't hear you.
Thank you, Madam Mayor. I will comment as I need to, but I really would like to have the attorney's input here first. Thank you.
Well, the purpose of this ordinance, is to really address a longstanding problem and do it in a way that complies with all of the relevant laws, but also create a safe haven, if you will, in areas of the city that are predominantly residential areas with the proximity to children and more and we spend a lot of time looking at relevant laws in the community and in the state of Alaska in order to provide protection and also protect constitutional rights and the importance of allowing the city to have all of the resources, including rehabilitation programs and all of the services that the community has put a lot of emphasis on, and to make sure that we didn't disturb that. This took a lot of research because this has not been done in the state of Alaska on a municipal level that we could identify. There are a few communities that have a prohibition of certain types of facilities, but not a proximity requirement. So what we're looking at here is putting in place restrictions as far as where sexual offenders can reside in relation to child care facilities and child care facilities and schools and other areas. And then we're also looking at making sure those provisions protect certain residential neighborhoods from it's really, the other thing to note is that we are looking to council to, one, you ask that we bring you something that shows you where you can go, or where we believe you can go under the law. And we have done that. But one of the other things, because we don't know a lot about what would be permissible for the state of Alaska, since we're going into new territory, we also are looking to council for a direction to perhaps go to the Attorney General and seek an opinion so that we can find out what the state of Alaska Attorney General's office feels regarding the scope of the city's authority to delve into these types of regulations. It's a lot of information, and we can get into more detailed information, of course.
Colleen?
Thank you, Madam Mayor, and this is to Ms. Wells. So as we look at kind of exploring this particular ordinance, through the Fair Housing Act, there is a protective clause, if you'll remind me, Holly, for those with drug or alcohol issues, but sex offenders are not considered under a protective class. Is that correct?
That's correct. The Federal Housing Authority, the FHA, so it protects the ability of anyone who is classified as disabled to receive fair and equal treatment in housing. What that means is if you have a rehabilitation program, a person who has addiction or is recovering from an addiction would be covered by the FHA, and we would not, the city would not be permitted to say, allow what might be a multi-family use, for example, in one area, but exclude or prevent a use that is similar in all respects, that puts the same taxes, the area or the district in the same way as a multifamily house, but create a prohibition. Because what the FHA will tell us is, well, why? Why are you treating the same group of people, same size, the same load, basically, on that area? Why are you treating them differently if not for their disability? And so the city needs to be careful and is careful to make sure it never does that, it does not do that, and it complies fully with the FHA. A person who is a registered sex offender, and this is an important difference than just a person who is a sex offender in the state of Alaska. But a sex offender registered with the state of Alaska is not in a protected class. Now, they may have disabilities that are subject to the FHA, and we have to be respectful of that, but they're two separate issues. So when we're looking at a person who is a registered sex offender, we are looking at that conduct and regulating that conduct alone, and not doing something that would make presumptions about that conduct and how it relates to any protected class of individuals. We're trying to regulate it otherwise. But another point to make, and this is a little different, but it's important to note, we're very careful to talk about registered sex offenders because in the state of Alaska there was a case in which the Alaska Supreme Court said that the state of Alaska, which had a registry, was acting unconstitutionally in that it did not have an exemption with that registry. So even a sexual offender who, say, they had an indecent exposure because they urinated on the side of a building or something like that and were classified as a sex offender, that person would not have the ability to apply to the state for exemption from having to register. And the Alaska Supreme Court didn't like that, and it said that when you have a person who is on the registry, you have to give them an opportunity to show they are not a risk to public health and safety, and therefore do not belong on the registry. And now the state of Alaska has that. It's constitutionally mandated to have that. And so for the first time, the city of Wasilla or another municipality can put restrictions on registered sex offenders and know that sex offenders that do not pose a risk to or a threat to public health and safety will not be on that list. So that is why the ordinance is geared towards prohibiting conduct or restricting housing of registered sex offenders only, and not sex offenders as a larger class.
Mr. Brown?
So, to make sure I understand, so a registered sex offender who has followed all the prescribed mandates by probation or parole still has no rights to live, we decide he shouldn't live there.
Correct. If they are a registered sex offender, unless they apply for exemption, and so one of the things this ordinance does is it sets up a hearing process to ensure that a registered sex offender, even though they do not have, even if they're complying with everything, if they are registered, these restrictions will apply to them. It does, however, create an exemption process because there may be reasons why a registered sex offender needs to be at a needs to be located in a particular area that is within the prohibited areas, is within the safe zone. One reason, this is very hypothetical, but there could be a medical program, for example, that's within the parameters of a safety zone, and you may have a registered sex offender that has cancer or something that this program is geared toward, and they need to enter into a treatment agreement, and they would be residing in that area. So this sets up an exemption process so that they can get access to the things that
But if I may follow on,
Yes.
so if you have 5 sex offenders who are alcoholics, then they would be protected and they could live in a residential area for that alcoholic treatment.
No, because if you have, because they are, this restriction is on their sex offender status, not on their, so they cannot, it's not discriminating against anybody based on their needs, right, to participate in a program. But a program that wants to be within one of these areas will have restrictions on who can be there. So it would, if the prohibition falls based upon their sex offender status, not their, so they, just by fitting within another class is not going to exempt you from the restrictions of this class.
I guess I'm not clear, but go ahead.
Yeah, I often get that feeling when talking to our attorney. But Ms. Wells, a couple of questions for you. Number one, let me back up to it here. I like things. So a person cannot permanently reside in a prohibited area, but this proposed ordinance would allow those currently living in prohibited areas to continue to live there, but they could not establish a new residence. And it mentions a purchase or a lease. So if the person's a registered sex offender was living at address X, which was in a prohibited area, and that lease was up, would that be considered, would that be a trigger for them to move out of the prohibited area? Or a second theoretical would be is if the person reoffended and was, adjudicated or whatever, and then released from correction, could they move back into that property that they had that was in that prohibited area? A couple of questions just when I read that one paragraph, or actually that one sentence that popped up. Could you comment on that, or?
Sure. A person who currently has a property interest in a residential zone, that would be where they would now be prohibited, they get to stay there and complete their interest. If they own a house, that means so long as they own that house, it is permissible for them to reside in the residential area. If they lease, they complete the term of their lease because they currently have a lease interest. And this is really a requirement, because while a person who is a registered sex offender is not a protected class, they are a person. And in Alaska, we have a constitutional right to privacy, and we have heightened protections of our property rights. So Alaska's constitution is very strong. Its protections are very strong. And what that means is if a person has a home or they have an interest in a lease, that's a property right that we don't take away without due process. And to take that away from somebody based on an ordinance like this would be, in my opinion, it would create a lot of vulnerability for the citizens. I don't think that is within the legal parameters.
So were you saying, to follow up on Mr. Brown here, were you saying that a person could extend their lease or release the same property because
they
they had an
cannot
interest,
enter.
because they currently have an interest in that, or they would have to establish a new interest in the property through a new lease or extension?
Which they could not do. So, and I think the language, the way it's drafted is if you have an interest, you can complete and maintain that interest that you have. But when a lease expires and you renew, that's the creation of a new lease, because your interest runs from one date to another, right? Your start date to your end date.
Right.
So what that allows, it's basically a grandfather clause. It allows people who are living in these areas, who are registered sex offenders currently, at the time that this ordinance is adopted, to remain where they are living and to complete the interest that they have. So you could feasibly have, and will have, if this is adopted, registered sex offenders who continue to live in these neighborhoods and the residential district. You also, with the supervised housing program, that also permits current housing, our current participants in the program or in a program to complete their program.
Okay, again, second question on a different thread here. This kind of came to light for the city council when a resident testified about a multi-unit property that was being offered essentially to persons that were sexual offenders or on the sexual offender registry list. So you had multiple offenders living in the same multi-unit property. Now this talks about being 1,000 feet from a prohibited area. Could an ordinance specify that in a residential area, in an area with residential zoning, that a person that's on the list could not live within 500 or 1,000 feet of another person on the list? Oh, I love it when you question like to prevent kind of this clustered, housing sort of situation. Sexual offender list friendly neighborhood, so to speak.
We looked for research that shows a relationship between having one sex offender next to another sex offender. Could not find the research that we would need in order to present to council the types of considerations that council will need to, which you're doing right now, that hard work of really thinking through what is reasonable and what is attenuated and what is linked. But in some cases, you will have reports that suggest that there's a heightened risk to safety, We have the fact that individuals on our registration list in Alaska have the ability to seek exemption because of whether or not they pose a risk to health and safety in Alaska. Either they haven't sought the exemption or they have sought it and it has been denied. So we have the state of Alaska telling us that individuals on the list pose a risk to health and safety. What we could not find was any evidence that suggests having 2 sex offenders in the same area poses a heightened risk, that there's some link there. So it was our determination that a restriction on where people live in proximity to others who are also on the registered sex offender list was not was a seemingly vulnerable, and again, we don't have a lot of yes and no answers, right, in the law in this area, so, but I would say it would create more risk. One of the things we did look at,
More risk to the city, risk of,
more legal risk of challenge and a risk to the council for stepping outside the constitutional rights of the individuals. The one thing we did look at is when you have a supervised program, when you have individuals that are being drawn to a program based in part because of the services they need, or it's a transitional program that doesn't qualify, say, as a correctional facility, but is a collection of individuals who are transitioning back into society and have violated the laws, perpetrated crimes, and putting all of those individuals in a single program, right? And you have that sort of heightened risk, arguably, but it's not necessarily. So when we look at those programs, we wanted to make sure those programs could function in a residential neighborhood, because sometimes those programs are small groups. They're designed to be very similar to a family-like setting as far as what the parking looks like, what kind of, how they're using the space, how many kitchens they have. All of those things are very similar to what you might find in a residential neighborhood. Those programs are often very successful. Putting all of those programs in a commercial district, for example, the research that we saw, that doesn't always benefit the community. That doesn't always lead to strong programs. Some of the smaller ones are very successful. So looking at that, this code protects the right for these supervised programs to stay within residential districts, but it does prohibit them from housing registered sex offenders in those programs. So that ensures that supervised housing programs can be open throughout Wasilla, and they can function in the residential district or outside of it, but if they're going to house registered sex offenders, those need to be outside the residential districts, outside these.
thank you. Thank you.
Mr. Brown?
Still a little confused.
Okay, sorry, I will try to.
No, I get your answer, but again, I'm familiar with several programs, and I'm familiar with incidents where a sex offender has more than one problem, whether it's alcohol, drugs, either way. But what you're telling me is that person could never get treatment in any residential area in Wasilla, in theory, because each residential area could say, we don't want you because you have a sex offender. Yeah, you have an alcohol, drug problem. Tough, you can't get it here, so I can get it nowhere in Wasilla. So what am I to do?
You would be able to get it in Wasilla, just not in a program that's in one of these districts. Supervising housing program in one of these districts, there's only very few that can even operate in these districts, because most of the time they would require, so they have to fit a certain characteristic to be in a district. There are many programs that would operate or could operate outside the residential districts. Does that make sense? So their programs are there, they just would be programs operating in the commercial, industrial. But you're right. If you were a registered sex offender, you would not participate in what we call a supervised housing program in the
But if I'm just a drug addict, then I could be in any one of those locations because I'm protected.
Yes, you could participate in one of the other programs. So you could participate in a residential program.
Because I'm protected because I'm a drug addict. But if I'm a drug addict with a sex offender, I lose that protection.
You would, yes, you would lose that protection. You wouldn't lose that protection. You would still be able to participate in one of the other programs. You just, as a registered sex offender, you have lost the right in the city of Wasilla. If you pass this ordinance, you would lose the right to participate in a program within a residential zoning because of your registered sex offender status. Remember, there are other sex offenders that may be able to participate in those programs. So if a sex offender who is able to show through the state process that they do not pose a risk to health and safety, then they wouldn't necessarily be a registered sex offender, right? If that was true, then they wouldn't have to register, and then they would be able to participate in that. So that the only sex offenders prohibited from participating in a supervised housing program within a residential zoning district are those that are registered.
And one last question. Did you find any evidence any of these homes has caused any problems? The people using these homes caused any problems?
I think that there's been, calls and letters to the community, but I would leave that to council. Because we did not, so there were letters sent, but I did not find, we weren't looking at police calls, for example, from these programs. We weren't looking at what crimes were perpetrated by the residents or participants in any program or in any neighborhood. So those may be really valuable pieces of information to seek from the city prior to adopting.
Thank you.
Mayor.
Good luck.
Okay, excuse me. It really makes sense to me because we really need to protect our residential communities. I mean, if I had a house by me that had 7 sex offenders and I have little kids running around, I would be worried. And these sex offenders do have the opportunity to file to say, hey, I'm not a risk, and have it looked at and have that part taken away. If it doesn't get taken away and they are registered sex offenders, do we want them in our residential areas where there's children and such? I say no. If they don't pose a risk, then they need to file for the exemption. Then they can be there. But I would not want a registered sex offender who is not exempt to be next door where I have my grandkids and other kids all over the place. So I'm totally for the ordinance. How would it be policed?
Well, I think there's 2 things here. So one of the things we would want to make sure we do too, and this is why I do recommend the Attorney General, is just to find out exactly how the state is functioning, because that Supreme Court case came down not that long ago. I would like to know exactly what that looks like and what that process is before we adopt. Here we have an exemption process, but we want to make sure we coordinate that. As far as policing, another benefit of having it tied to a registration, it allows someone to raise a complaint, and we're not trying somebody. This is not all we're doing is looking at the state registration. If their name is on the registration and there is a complaint, and it would really be complaint driven, right? It would be, I don't anticipate that, and this is something that we'll discuss more, but I don't see, much like any other violation, either land use or otherwise, the city actively checking up and engaging in it. They're going to presume people are complying with the law unless they have a reason to suspect otherwise.
Thank you.
Mr. Graham.
Thank you, Madam Mayor. So looking at this proposed ordinance again, that at this point we're not acting on, we're just saying that we'd like the state to look at this. Starting on line 125, request for exemption, And this is not a request for an exemption from the sexual offender registry list. This is a request for exemption from the rules of this ordinance. What is proposed here that says, you know, if you want to live in a residential area, you know, let's say you're a registered sex offender and you want to live in a residential area, and the city says, no, that's within 1,000 feet of a prohibited area, well, all you've got to do is ask for a hearing, and this hearing is going to be held by an administrative hearing officer, which typically is an attorney and is not responsible for enforcing the code according to this. I mean, there's nothing in here that says the hearing officer may not grant an exemption, you know, based on certain things. This pretty much leaves it completely up to a hearing officer that we didn't appoint. I mean, the city council doesn't appoint those. The mayor appoints the hearing officers, and the hearing officer, if we disagree with what they did, then we can ask the mayor not to use that hearing officer again. It's pretty much our ability to respond to something. And I mean, currently we're seeing, you know, even attorneys generals for states deciding that, well, I'm not going to enforce the laws regarding whatever, and we're even seeing it here, you know, for shoplifting and other offenses that, well, we're just, you know, the courts just let them go. So I am really uncomfortable with the fact that a person can make an appeal through a hearing officer who has no responsibility, you know, or no authority granted by the council here. Why would the council make an ordinance and then have it just left completely in the hands of a hearing officer when, you know, when it looks like they have carte blanche to essentially waive the ordinance? Can you perhaps comment on that?
Sure, although I don't think you'll like my answer.
Well,
But
I didn't ask you for an answer I'd like. I just asked you for an answer.
So I would say that given the interests at stake and what you're governing here, it is important to have an officer of the court make this decision. And if it's going to be appealed or you're going to be accused of a constitutional violation, you want someone applying that balancing test and really looking at the imminent harm that the individual seeking the exemption is reporting. Because if this is triggered, it is somebody saying that by applying this to them, you are violating, in essence, their constitutional rights, or that they are being harmed. And in that case, you want someone who's got the books out in front of them. They are looking at the cases, they're listening and weighing both sides, and they have as much distance and neutrality as you can give them. And having someone who's appointed by council, somebody who has any sort of legislative position, or that council has oversight over, other than simply appointing someone that meets certain qualifications through the clerk's office, which is usually how that's, you know, done. I think that creates danger. I think their decision will be held, they'll be held accountable for that decision through a further appeal process if it comes to that. I think this would really. So I would say it's drafted intentionally to create autonomy to the greatest extent possible. Notice it's also not the city attorney, right? It's a appointed officer. I believe the clerk's office maintains a list. They're all municipal lawyers or legal counsel in the community. And so they will be very aware of the risks they're putting the city in if they issue a decision that doesn't protect their rights, as well as comply with your laws. But if you wanted to go the other way, I would be very, very nervous about that.
And if someone appeals, for instance, a ruling of the planning commission, there are certain costs that person has to bear to make that appeal. There's no mention of the appellant here making, you know, of this costing them anything other than costing the city's time and money associated with making that. Do you think it would be appropriate to have a clause in here that makes the appellant responsible for the costs if they, if their argument holds water, so to speak?
I don't think that, unlike a land use provision where you're dealing with a property right in those cases, but because of the nature of the code, you're very rarely dealing with us telling someone where they can or cannot live in a particular time. So with the request for exemption, we tried to make sure that this actually was a process that was accessible, you know, and so didn't have a cost associated with it, had a hearing officer, created a pretty significant access to the process, really. So that's what was done here. I don't think it would be unlawful to require that you could do that. But I do think given the nature of the interest, it makes sense not to.
Thank you. And for the record, I think there should be a cost, not necessarily an upfront cost, because if this is a person who's fresh out of jail, is not going to have access to a lot of cash probably, but there should be a cost associated with this that the city could recover through the attorney, you know, through PFD garnishment or, you know, some sort of court settlement where this isn't just an open invitation to anybody, you know, if you're on the list, well, appeal it and see if you can get away with it. Because that's kind of how I see it now. I mean, it's kind of an open door. There's no reason not to appeal, you know, the city's decision that you can't live within 1,000 feet of a prohibited area. Thank you.
Is there further discussion? Hearing none, I need a motion to exit the committee of the whole.
Madam Mayor, I move that we exit the committee of the whole.
Is there a second?
I second. Madam Mayor? I move that we, oh, I'm sorry. I jumped.
Is there objection to the motion? Hearing none. We are out of the committee of the whole. Now, is there a motion to approve AM number 22-12?
Madam Mayor, I move action memorandum number 22-12.
Is there,
I second that.
okay, it's been moved by Councilmember Sullivan Leonard, seconded by Councilmember Velock. Is there an objection to the motion?
Madam Mayor, I object.
Councilman Brown, object.
Okay. Is there further discussion?
Go ahead.
Madam Mayor, I object because I think we should have the attorney consult with the Attorney General before we move this forward. There's several legal questions I believe is present here, and I think we will gain a lot of knowledge and support if we go down the road of the Attorney General's office to have them look at this and advise her further, and then bring it back to council. Thank you.
Madam Mayor, to clarify, I believe that's what we're doing, aren't we?
Is that the motion?
Yeah, that's
Oh,
my motion,
Oh,
was to have the attorney then bring this
I
forward
thought
to
you was moving
AG.
to approve.
No.
No. All this is to take it to the Attorney
Okay,
General.
I just heard her give the motion number and nothing else, so.
I apologize.
Okay, any further discussion? Stu?
Thank you, Madam Mayor. Madam Mayor, I move to amend AM number 2212, authorizing the request for the opinion to specify that the opinion should include the State of Alaska Attorney General's opinion on recovering costs of the hearing.
Okay, the motion's been made. Is there a second?
Councilman Brown, second.
The motion's been made by Councilmember Graham, seconded by Councilmember Brown. Is there further discussion? Pauline?
Yeah, thank you, Madam Mayor. I don't think we're at a point to figure out yet what the cost may be for somebody who may be filing for an exemption for this particular piece. I guess I'd like to see what the Attorney General for the state of Alaska has to say prior to us making that movement. So I don't support that amendment.
Further discussion?
Madam Mayor? Yeah, so in response to Councilperson Sullivan Leonard, just to be clear, I'm not asking them to assign a cost or to say that we assign a cost at this time, just to say whether or not it would be constitutionally permissible and defensible for us to recover costs or to include a clause in any proposed action. Thank you.
Ms. Wells?
There's just one thing I would say is, so one of the reasons why we go to the Attorney General is because there is a question about preemptive authority. We are going to do something that the state of Alaska, unlike many other states, the state of Alaska has chosen not to do within its jurisdiction. And we're not sure if it's chosen not to do that because of the probation process that we apply and the requirements and restrictions it places, or if it's chosen not to do that because it hasn't extended its authority. So we don't know if the state takes the position that we can, as a municipality, exercise this authority. And that really is a very appropriate arena to go to the Attorney General. When it comes to costs, while we make that decision and we'll weigh and balance what the cases say, I do see cost of any sort of appeal process or the process you guys adopt as a body well within your authority. So they will weigh that when we look at costs, if we're setting up an appeal program, for example, and here a program designed to determine whether or not we violated their constitutional rights, that's one of the reasons why I, as your attorney, would not recommend you adopt a cost program, because we're talking about looking at their constitutional rights. That doesn't mean you necessarily can't. And I can do the research within the municipal realm and let you know what your parameters are and what your options are. I would prefer not bringing that to the Attorney General because I value the municipality of Wasilla's autonomy, and it's your right to make the decisions that are within her. If that makes sense. So I'd like to limit what we ask them to this arena of what we do compare it with what the state does.
Madam Mayor, given that explanation, I withdraw my amendment.
Okay, we are back to the main motion to approve AM 22-12. Is there further discussion? Hearing none. Is there objection to the motion? Hearing none, the motion is approved. We are now at communications. Madam Deputy Clerk, please read the titles of the items under communications.
Thank you, Madam Mayor. We have one IM and 2 sets of commission meeting minutes. IM number 2206, monthly financial reports for the period ending April 30th, 2022, to include the month-to-date expenditure report and disbursements greater than $10,000. Commission minutes, Airport Advisory Commission minutes of April 21st, 2022, and Parks and Recreation Commission minutes of May 11th.
Thank you, ma'am. We are now at audience comments. Is there anyone present who would like to address the City Council at this time? If so, please come forward and begin by stating your first and last name. Comments are limited to 3 minutes per person. Seeing no one, audience comments is closed. We will move on to the mayor, clerk, attorney, and council comments. Madam Deputy Clerk.
Thank you, Madam Mayor. On behalf of our whole office, we just wanted to thank and congratulate Troy and on his retirement. He's been a great mentor to us and just a great resource in helping.
Madam Attorney.
Thank you, Madam Mayor. I try not to do this very often, but I think Troy is an exception. So I am going to say I've worked with many finance directors across the state of Alaska over the last 15 years. and Troy Tankersley is one of the best, if not the best, finance director I'm working with. Wasilla was really very blessed to have him at the helm.
Councilmember Graham.
Thank you, Madam Mayor. A couple things. First, I wanted to ask our Public Works Director about the Hurley Circle utility extension. And Hurley Circle is that pathway, driveway, whatever we want to call it, behind Fred Meyer that accesses that there. So tonight during the consent agenda, we authorized, quite a bit of money to tie water and sewer down to the end of Hurley Circle there. So I was wondering, Director Bischoff, if you could tell me, what is the benefit to the city of having that, or is the benefit purely to the landowners there? And secondly, is the landowner / owners participating in the cost of that utility extension?
Danielle Bischoff, Director of Public Works, through Mayor Ledford, through Councilmember Graham. So what we did tonight was we introduced that ordinance for public hearings on June 13th. The City Council on November 22nd approved the funding for the design of this project. There were commitments made to Katie Hurley back in 1999 when Fred Meyer went in that utilities would be extended to that property. Those utility extensions did not happen at that time, and it was overlooked. Since then, her heirs have sought to have the commitment that the city made upheld and the utilities extended. The extension of these utilities would serve all of the properties that are back there. There is only one developed lot back there at this time, but it would have the ability for the other lots that are there to service into those lines. The city has not sought to have the homeowner take on this financial obligation. It was, as I said, it was brought forward for design, which is been completed, and we are now seeking the funds for construction.
Okay, thank you, Danielle, appreciate that. Second thing on my list tonight is I was able to attend the graduation of all three of our Wasilla schools, the Wasilla High School, Burchell High, and Matsu Central School at the Menard Sports Center. Of course, the Menard did an excellent job, been doing a great job with graduations for years, and I'm sure we'll have another 50 years worth of graduations there. But I just wanted to say how much people came by and said, hey, I appreciate the city council showing up and being there. And in previous years, we've had a larger presence there. We didn't have much of a presence this year. But I highly encourage you to put that on your list for next year. Come to these graduations, see these kids, feel the excitement. I graduated from high school in 1975, so it's been a while since I've had that kind of excitement. But it's interesting to watch these kids and see how excited they are and see how much they look forward to their future, and to kind of hear what they're thinking through their speeches, the valedictorian, salutatorian speeches, as well as other comments that they make from the dais there. It's really interesting to listen to them and find things out about them. So I'm just suggesting that next year, let's all put it on there and let's show up in mass and show them that we really appreciate the work that they do and the work that they're going to do in the future, because they are certainly our leaders for the future. And lastly, Troy, man, what a hell of a job you've done over the years. I remember when I first came to the council, I know a thing or two about accounting, but government accounting is a totally different animal altogether. And you were kind enough and gracious enough and patient enough to help me understand the differences and see where things went and answer my questions over the years, even though I'm sure you, back of your mind, where your eyes were just rolling back in your head going, oh my God. But thank you so very much for all your help, for all of your years of service to the city. I wish you a happy retirement. filled with something other than numbers. Thank you, Mr. Tankersley. Thank you, Ms. Mayor.
Councilmember Brown.
Thank you, Madam Mayor. First, to the attorney, thanks for your explanations. I ask these questions only because I've seen things in the past that results in this city or other entities being sued for jumping the gun too quick. So thank you for all the explanation you gave there. And Troy, for the short time that I worked with you, thanks for all you've done for the city. And when I look at the city accounts and our savings account, that tells me either you or your assistants was doing something wrong right in there. And since you're leaving her in charge, I'm sure it will continue for what you started. So again, thank you very much for what you've done for the city of Wasilla and all the residents of Wasilla.
Councilmember Sullivan Leonard.
Thank you, Madam Mayor. I know that they had many graduations this past week, and certainly I would have loved to have been there, but I hadn't seen my daughter in 3 years. And so I was traveling to the East Coast, to a little town of Hamburg, New York. So I was happy to see her and granddaughter and grandson that I hadn't seen in 3 years either. So I've been to many graduations and certainly hope to in the future again to see our great students graduate from high school and move on to life. But honestly, with regard to Mr. Tankersley, we've known each other for a long, long time, and I appreciate your hard work and putting up with me over the years. But honestly, your work has been exceptional, and I wish you all the best as you retire and move on to the next chapter in your life. So thank you again, Troy.
Ms. Velock.
Thank you, Madam Mayor. I too attended quite a few graduations this week. If I quit having grandkids, there's always one graduating 5th grade, 8th grade. High school, yes, I went to plenty of promotions and graduations this last week. But yeah, they're fun and they are exciting no matter what the age. They all think they're heading out to bigger, better things. They are. And Troy, thank you. It has been a pleasure working with you. And it's kind of sad not to be able to see you there, but I'm excited for you. I know you're going to have a great time. And retirement's great. It's great to sleep in. So have fun. Thank you for all you've done.
Councilmember Rubio.
Okay, about graduations, you need to come to a preschool. You think high school, like what I attend, is amazing. But anyways, on that note, congratulations, Troy. Enjoy retirement, hopefully on a boat somewhere.
Okay. Troy, who am I gonna bitch at now? Who's gonna be gone? Who's gonna tell me, no, you can't do that? Well, why can't I do that? She might not be as patient as you, you know. I about had you trained and you're going to retire. So, but Troy, I honestly appreciate the job that you have done for the city. As many of you know, the city is debt-free, and that is because of this man's foresight of where we are and where we need to be. I appreciate everything that you have done. I appreciate your help in helping me settle in as mayor, because it's a different world than cutting hair. So, but I do appreciate everything that you've done, because you have been a good leader for our city. And if you hadn't been that type of leader, we could be in dire straits like a lot of them are at this day and time. So thank you. And go and enjoy yourself. I won't call Wanda but once a week. Okay. So, and with that, this This has been a long time coming, I think, in the city of Wasilla about these sex offenders. And we are breaking new ground. So it will definitely be interesting to see how the Attorney General looks at this. Because you know, he very well could say, no, get out of my face. But he could also come back and say, okay, you need to do A, B, C. I think it will be a good starting point. Because look, when we banned the plastic bags, everybody followed suit. So it's a starting point. And Holly, I appreciate your work on this. And it's hard to understand some of this stuff from a layman's point of view of, well, why can't we do this? You know. So I do appreciate all of that. And to John, I have all the confidence in the world that you will step right into Troy's shoes and do a great job. I'm looking forward to working with you, and I'm sure if we need him, we'll call him. You know?
Might not answer, but.
Good hands, Mayor and council.
Absolutely. So with that, there's nothing else to come